Hello everyone and welcome to video 2 on the civil courts, the outline of the procedure of a negligence case up to trial. So how we get from starting a claim up to the point of trial. This is the second of 3, don't forget, of our videos of civil courts. Now I have to say this is a little bit dull-tastic. It's about forms going backwards and forwards. I will try and make it as entertaining as I possibly can, but unfortunately it is just about claimant A makes the form, defendant gets the form, he sends it back to claimant A. Unfortunately, we have to know that procedure, so just bear with it, make some notes, and as I said, try to get the general outline of the procedure from the moment that somebody wants to start a claim of negligence in the civil court to the point at which the court date and the trial starts. So that's what we're going to look at in this session. And our starting point is to say that the majority of cases are settled without going to court. And of course we spoke about that, and we said that that's normally through a mechanism that is known as ADR, or alternative dispute resolution. And some of you might have remembered that if you'd have studied ADR in Unit 1. But if not, it's the alternative dispute resolution, covers all of the ways in which people who have a disagreement settle those disagreements without going to court. And in terms of which court we start the process at, if the expected awards are less than £50,000, so that in case you didn't know, that's the less than sign. So if the awards are likely to be less than £50,000, then the court will start in the county court. For all other cases, they will start in either the county or the High Court, depending on a number of factors. And what I'm going to concentrate on through the process of this video is the process to county court. And I'm going to do that predominantly because the majority of cases, it's fair to say, start in the county court. So, the first part of the process. And let's say, for instance, let's have a think, what can we use as an example throughout so I can keep coming back to and referring to. We will do a claim after a car accident, and I'm claiming for the cost of the damage to my car after a traffic accident. And the first thing that I have to do is that I have to complete a claim form. Okay, now there are, and as I said, there are lots and lots and lots of forms for different sets of circumstances involved in this process. You can download them from the internet, or they can be collected from one of 200 offices around the country. Now, for those of you that aren't aware, if you go to the website, thelawbank.co.uk, there is a link on the links page that will take you to the place where you can download these forms. I'm just trying to find out whether or not it breaches copyright before I put them up, but I'm going to try to put them up anyway so as people can download them straight from the form, straight from the site. It is worth taking a look at the claim form, predominantly because it gives you some idea about the process. It helps when you visualize things and when you can sort of physically look at the form itself and see what has to be done. It makes understanding the process quite simpler. And the first step, it's a two-sided form, I have to say. I've only got side 1 here, but it's a two-sided form. And the first step is to fill out side 1, obviously. And I say that because you don't have to fill out side 2 before you can send it off. But essentially it requires your name and your address for both the claimant and the defendant. So we've got the claimants, this is C and this is D. So you would have to put down your own name and address and the name and address of the defendant and the very, very briefest details. So 1 or 2 sentences, okay, of the details. Oh, I can't write tonight. So 1 or 2 sentences explaining the brief details of the claim and then the value, how much you think that's worth. And the purpose for that is to establish I've got that down here. The purpose for putting the value on the original claim form is it allows the court to see what is the fee payable All right, so how much they're going to charge you, and yes, this process is not free. It will cost you money, and perhaps we can start to think about the barriers to access to the law. The barriers of access to the law. That's a better way of saying it. An awful lot of claimants, particularly in the small claims courts, are not going to be very wealthy themselves, and the fees that ratchet up before court can be a very clear barrier to stopping people trying to claim liability and negligence. So the first reason why we put this form in with a value is to look at how much of a fee we are going to be charged. And the next thing is to look at the choice of court. What court are we going to start in, and what track are we going to go on to? And I'm going to talk you through the track system in a moment. All right. So the side, as I said, contains two sides, and side 2, so the second side of that form that we saw earlier, so side 2 contains more detail. So side 2 contains more detail. And that can be sent separately, which is why I said earlier on that you fill out side 1 first. You can send side 1 off quite quickly, and then you have 14 days to fill out side 2. So side 2, you have an extra 14 days to complete. And that's a simple statement of facts on which the claimant is basing the claim. So for instance, side 1 might just have said, I was involved in a road traffic accident with the defendant and my car was damaged. That would be side 1. Side 2 would contain a greater level of fact. So it would say things like, on January the 13th, 2013, I was driving along the A140 en route to Colchester to watch the football. On that journey, I was involved in a road traffic accident. The defendant was driving such and such a car. You get the idea. It contains more detail. It talks about the time, date and place of the accident. Now I'm using a car accident, but it could be any form of accident. And it outlines why the claimant considers the defendant has been negligent. So you've got to say why you think the defendant was negligent. The fee payable will depend on the size of the claim, but it's roughly around about £150 for a simple claim. That's the fee payable for a simple claim. And there used to be some financial aid possible for low income, but as the legal aid budget is trimmed and trimmed and trimmed, that becomes less and less. And I'm not going to lie, that changes frequently, and certainly I do not know the current state of play in terms of how much legal aid is available for claims in tort, if at all. So the next part for that is that the claim form is served on the defendant, and it's normally served by post. So we normally put it in the post. As well as the claim form, the defendant will also get forms for dealing with the claim, and we're going to look at those in a moment. The claimant will choose the county court that he wishes to start the claim in, so not only what type of court, but also the location, and that might get transferred to a different court at a later date. Okay, so it's served by post. The claimant on it will say, I would like it to be heard in this court. The second step in this process is that the defendant receives the claim form. And I've got 3 forms here, which make up effectively a response pack. Okay, so these make up the response pack, and they will be an admission form. And the admission form is to effectively say, yes, I agree. It was my fault and I will agree to pay. There's an acknowledgement of service form, and you can see that's attached to the bottom of the response pack. That basically says that you have received the pack. And thirdly, if you are not going to admit it, there's a defence and counterclaim. Now that means that the defendant can do one of 3 things. The defendant can either do nothing and not reply. Can ignore it. Not a brilliant strategy, I have to say. the defendant can admit all or part of the claim. So when they get the details, they may say, yes, I was driving the car. Yes, I was liable for the accident, but I'm only liable for the damage to the front wing because actually the damage to the rear wing was already there. You know, they could admit all of it, or they can just say, yeah, the whole damage is mine. They can admit all or part of the damage or the claim. And the third is they can dispute all or part of the claim. So the defendant has a number of options available to them. They have to do this within 14 days. So they've got 14 days of receipt before they have to reply back to the court. And if they don't do anything within 14 days, then the claimant, so if they don't complete it, C can file for a default judgment, which essentially means the claimant can file for a judgment in their favour. So that's why doing nothing and not replying is not a good idea, because essentially it means that the claimant can win for a no contest, or can claim for a no contest win. And if that's the case and a default judgment is granted, the court is only concerned with awarding the level of damages and the costs. So if that's the case, then the court concerns themselves with damages and costs. And they do that by allocating to the small claims track or to a disposal hearing if more complex. So they will, if there's a default judgment, it either goes to the small claims or a disposal hearing. Of course, the defendant could make an offer of payment. They could make an offer outside of court and make an offer of payment. So if that's the case, then they would normally either settle outside of court or acknowledge the service of the document, which would give the defendant an extra 14 to 28 days. So you can start to see already that from the moment we started our claim, depending on which way the defendant chooses to play this, we are starting to ratchet up time. Time is starting to, as I said, mount up, and we're already probably at around about a month in at this point. What will then happen is that this will then be sent, step 3, back to the claimant. So the claimant will receive the defence. And when the claimant receives the defence, the court will also send out allocation questionnaires to each party. And the purpose of the allocation questionnaire is to find the location, so which court is it going to be held in, what track it's going to be on, and we're going to discuss tracks in a moment, and the timing of the trial. So it's allocating a location, a track and a timing. And if you remember, there was a fee to start the process of £150-ish. And there's now a new fee for allocation, so an allocation fee of £100. And this is often seen as an incentive to negotiate. The court wants you to settle out of court. So if it makes the process expensive, it will force you to think twice about going through the court and to settle outside of court. Now, there is also a trial fee. And it's about £500 for a multi-track. Okay, and we'll look at multi-track in a minute, don't forget. So we're now already up to about £750 in total. And the courts will keep records of all the necessary return dates. So the court starts to look at and keep records of these dates, when they were returned, when the location will be, what track it's going to, what the timing is. And this is all part of case monitoring. And you'll recall case monitoring when we looked at criminal courts, the judge's job to make sure that the case is heard and tried at the right place and the right time. And the case monitoring is where the judge receives support from court staff to carry out case management. So case monitoring and case management. Okay. Once the allocation questionnaires are completed, a procedural judge will allocate a track. And normally the procedural normally the procedural judge will allocate a track, and that procedural judge will normally be a district judge. So a district judge is normally the one that issues the track. And he has one of 3 tracks to choose from. We'll come on to look at each of them in turn in a moment. At this point, failing to comply again may see you struck out of the process. So if at any stage here you decide to be awkward and not engage in the process, it may see you struck out of the process. And if you are struck out of the process, the party that is struck out is unable to take any further part. And that means that they would lose the right to claim or defend. And again, this is all part of the case management process. And its aim is to keep the process moving at a reasonable speed, so as people aren't waiting forever. Because in the past, even trivial trials have sometimes gone on for years. And courts want to avoid that. It's traumatic enough as it is without it going on longer than it needs to. And indeed, judges can now summons parties to court to inquire about the inactivity and how long the case has taken. So having got to that, we've arrived at the 3 tracks. What are the 3 tracks that are available for a claimant? Well, they are the small claims track, the fast track and the multi-track. And which one you use depends on the scope and the size of the case. Now, very, very frequently, AQA certainly will ask questions about the 3 tracks. And normally that's done by looking at the scenario and then expecting you to recognise what is the likely damages from this scenario, and from understanding the likely damages to be able to identify which track you'll go to. And remember what I say, the court questions are so easy that you should be picking up full marks for them. In summary, small claims are claims up to £5,000 with personal injury up to £1,000 and are normally, that says single, it should say simple, which obviously is what I am, for getting that wrong. So, and then normally simple cases. Fast track are for claims between £5,000 and £15,000. The trial is likely to take up to 1 day, and they are moderately complex. They're more complex than small claims. And finally, our big cases are called multi-track cases, and they are for claims over £15,000 and can often be very, very complex. We're going to look at each of these in turn for the final part of our video. Let's start with small claims. We've already said that it's likely to be less than £5,000. And personal injury claims, so personal injury is going to be less than £1,000. And by personal injury we mean, which includes claims for pain, suffering and loss of amenity. And what we mean by loss of amenity are things like the things that you enjoy doing in life. So loss of amenity, or things that you might have to be able to do. So loss of amenity might be that I am unable to shave. Loss of amenity might be that I used to be able to play golf and now I no longer can. I could never play golf in the first place, but you know what I mean. Loss of amenity means our inability as a result of the accident not to be able to do something that we did before. There are no complex issues here. These are straightforward. And if we think about my car and the car crash that I was originally claiming for way at the beginning, the likelihood is under £5,000 that this is where it would take place, in the small claims court. And this is normally heard by a district judge. The next serious or set of serious cases would be heard in the fast track. And they're normally for cases that are not able to be heard in the small claims. Their claim value is less than £15,000. Trials not expected to last more than 1 day, so it's relatively straightforward. There will be limited oral expert evidence. So in the case of my car, if my car was written off and it was brand new, then it might make it to the fast track. And the limited oral expert might be the police officer who attended the scene maybe, and the garage mechanic. So not a hugely complex set of experts to be able to give evidence. Some complex issues might be involved. So we looked perhaps the other day at res ipsa. So there might be a res ipsa issue that was involved here, so some complex issues, but nevertheless you would expect to see them ironed out within the day. And this is normally heard by a district judge too. Okay. The multi-track system are for our big hit-in offences. We are talking about over £15,000. So big cases. These are more complex. And they're almost always heard by a circuit judge. So a far more serious judge. And they will deal with any claim that isn't in the scope of the fast or the small claims track. And that's normally, it's not in the scope because of its complexity or because of its value. And finally, the last thing that I just want to look at is what happens between the allocation of a track and the trial. So after the court allocates a date, or sorry, I should say after the allocation, a date is set. So you've got allocation and then date set. So allocation, then on to date set. And that's no sooner than 21 days. So after the court date will be at least 21 days after the allocation. And the actual date depends on what other directions are needed. So that might be copies of documents might be needed. And it might take some time to get these together. Copies of expert statements perhaps. So those two things, you can use that time here, that delay, to be able to get these documents. And then it goes to trial. Once everything is in place, it then goes to trial. And there's been a push of late to try to reduce the time. It was about 1 year in the 1990s. It took about 1 year to get to court in the 1990s. And it's roughly around about 30 weeks now. Now that's still not ideal. That's still well over 6 months. But nevertheless, it's much better than the 52 weeks that we used to see in a year. So there we go. I admit, as I said earlier, it is quite dull. It's about he gets a form, he fills a form out. But it is relatively straightforward. You can almost always guarantee on AQA papers anyway, there will be a question that refers to one or more of the track systems. There is frequently a question that asks how a claimant will get a defendant to court. And of course what they're looking for there is for you to talk about downloading and completing a claim form. The defendant receives the claim form and the claimant receives the defence back along with allocation questionnaires. So they are relatively simple and straightforward, and because of that they are relatively simple to get full marks.